My name is Ellie Pressman of Barnet Wills, and very recently I did a post on how making a lasting power of attorney is so much cheaper and quicker than having a deputyship order through the Court of Protection. I had a number of comments on the post saying people understood what LPAs were, but didn't know what deputyship was. So in this video, I'll try and explain the 5 main differences between having a lasting power of attorney and a deputyship order. Now, the appointment of a deputy is similar to that of appointing an attorney, but the difference is that the deputy is appointed by the Court of Protection and can only be done after someone has lost capacity. Now, with dementia cases in the UK rising quite sharply, the chances of someone needing to make decisions on your behalf is increasing. So it's important that you do understand the options. Now, although an attorney and a deputy are similar, there are some key differences, and I'll go through them now. In order to make an LPA, you must have mental capacity at the time you make the document. You need to understand the concept of handing over responsibility to someone of your choice. So with an LPA, you decide who the attorneys are and make the arrangements yourself. And the LPA then needs to be registered with the Office of the Public Guardian before it can be used. A deputyship order can only be made on behalf of another person after they already lack capacity. And it's usually made to the court by the person wanting to take over the affairs of the incapacitated person. The key difference then is timing. Attorneys are appointed in an LPA while the donor still has capacity, and a deputy is appointed by the courts after mental capacity has already been lost. The second main difference is that under an LPA, you can choose anyone over the age of 18 to act on your behalf so long as they have mental capacity. And you can have multiple attorneys who can act either jointly or independently. With a deputyship order, the court will decide whether the person making the application is actually a suitable deputy or not. It's quite possible that the courts will appoint somebody that you didn't want or wouldn't have chosen yourself. And in the event that there's actually no family or close family members, then the courts could appoint the local authority to act as your deputy. The health and welfare deputyships are usually much stricter and more limited because it's difficult to make decisions without knowing what your wishes are. The third main difference is that an LPA can be registered in about 12 to 14 weeks and is completed in advance of you losing capacity. So attorneys can act immediately and can access your funds very quickly in the event that something happens. With a deputyship order, it can only happen after you've lost capacity, so it can take, I've seen over a year in some cases to get a deputyship order granted. So in the meantime, no one will be able to make decisions or access your funds, pay your bills, manage your care, and this can cause incredible problems if you require nursing care or if your deputy needs to sell assets like your property in order to fund your care costs. The fourth main difference is the cost. LPAs are much, much cheaper. The average cost of a deputyship order is usually about £4,500. Plus, on top of that, there are further supervision costs and yearly costs in having a deputyship. An LPA is £82 to register, and I typically charge between £125 to £250 to draft LPAs. Now, a lot of people say, well, you can go online and do it for free, and that is true. You're not paying a professional like myself to fill in a form for you. If you just want to fill in the form, you can do that for free. But if you pay a professional like me, then you do get added value. You don't know what you don't know. There are things that I put into an LPA that you wouldn't have thought of, which could lead to, in some cases, having a document that's not fit for purpose or will let you down when you really need it. The fifth main difference is the supervision, which I alluded to just earlier, and that is the level of ongoing supervision of a deputy is very different to an attorney. There are rigorous controls in place to ensure that a deputy is acting correctly, and that includes submission of annual reports, accounting for all the expenditure made, and that can be a very difficult and stressful time for the person appointed as a deputy. This is very different for an attorney who has not been appointed by the courts but has been chosen by you. So the courts take the view that as you've chosen the attorneys yourself, you trust them and that your judgment is correct. In some cases, the courts will investigate an attorney if someone has reported them or they receive a report to suggest that there's been something inappropriate going on. Although planning for the worst can be difficult, it is cheaper and quicker to have an LPA in place rather than a deputyship order. If you don't have an LPA, then all is not lost because a deputyship order will still allow someone to manage your affairs for you. It's been estimated that in the next 2 or 3 years, there will be 1 million people in the UK who suffer from dementia. The need for an LPA has never been more important. So do it now and have the peace of mind that should anything happen, your loved ones will be able to make sure that your wishes are carried out. Feel free to give me a call. It's free, no obligation to buy, and I'm happy to have a chat.